Indian Penal Code 1860 consists of 23 chapters and 511 sections. It deals with the laws which apply in India for the punishment of offenders. It is a comprehensive code intended to cover all substantive aspects of criminal law. It was enacted on 6 October 1860 and came into force on 1 January 1862. The first draft of IPC was prepared by First Law Commission chaired by Thomas Wivington Macaulay. Chapter 1, titled as Introduction, consists of a preamble and five other sections. Preamble says, whereas it is expedient to provide a general penal code for India, it is enacted as follows, meaning thereby that IPC is a general code and it is not exhaustive. Section 1 says title and extent of operation of the code. This act shall be called the Indian Penal Code and shall extend to the whole of India except the state of Jammu and Kashmir. However, after the J&K Reorganization Act 2019, Act number 34, Indian Penal Code is applicable to the whole of India, and the Act reconstituted the former state of Jammu and Kashmir into two union territories, one being Jammu and Kashmir and the other being Ladakh, with effect from 31st October 2019. Section 2, Punishment of Offences Committed Within India. Every person shall be liable to punishment under this code and not otherwise for every act or omission contrary to the provisions thereof, of which he shall be guilty within India. Now, Section 2 deals with the intra-territorial jurisdiction, that is, the offences committed within India. The term Indian territory has been defined to include land, water, inland water, including the rivers, canals, etc., and portions of the sea. Every person includes a person of foreign nationality also. In a case Mubarak Ali versus State of Bombay, AIR 1957, the appellant, who was a foreign national, made false representations to the complainant in Bombay from outside India through letters, telegrams, and telephone talks. So it was held that the appellant must be held guilty and punished under the IPC 1860, notwithstanding his not being corporeally present in India at that time. In R versus Aesop, it was held that no person can take the plea of not being aware of the criminality of an act in the country. However, there are certain exceptions. Even though Section 2 fixed criminal liability on every person, here are some persons who have been granted immunity from prosecution either by the Constitution of India or by international law. President and governors, foreign sovereigns, ambassadors, alien enemies, foreign army, and warships. Section 3, Punishment of offences committed beyond but which by law may be tried within India. Any person liable by any Indian law to be tried for an offence committed beyond India shall be dealt with according to the provisions of this code for any act committed beyond India in the same manner as if such act had been committed within India. Section 4 deals with the extension of code to extraterritorial offences. The provision of this code apply also to any offence committed by any citizen of India in any place without and beyond India, any person on any ship or aircraft registered in India wherever it may be, any person in any place without and beyond India committing offence targeting a computer resource located in India. Explanation: in this section, the word offence includes every act committed outside India, which, if committed in India, would be punishable under this code, and the expression computer resource shall have the meaning assigned to it in clause K of subsection 1 of section 2 of the Information Technology Act 2000. There is a relevant case law to it in Fatima Bibi Ahmad Patel versus State of Gujarat, AIR 2008. It was held by the apex court that The code has no application for an offense committed by a foreigner outside India. Section 5 limits the applicability of law on the specific class of people for whom different laws are already present in the country. So, Section 5 says certain laws not to be affected by this Act. Nothing in this Act shall affect the provisions of any Act for punishing mutiny and desertion of officers, soldiers, sailors, or airmen in the service of the Government of India or the provisions of any special or local law. We can say that Section 5 is an exception to Section 2. Section 2 makes the code universal in application within the territory of India on every person, irrespective of his nationality, rank, caste, or creed. Whereas Section 5 limits the operation of this code and says that wherever the special or local laws are there, those laws would prevail over the IPC.